anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Insurance claim and a visa claim.
Here's the thing, I haven't read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence.
The Zoom is sucking the speed out of my computer. Just hold on one second. I'm trying to actually pull up the case itself. Hold on.
Cases where I guess ChatGPT or whatever the legal version of the AI, research and writing.
Trying to do their job. I'm trying to do my job. The court reporter is doing her job, and everybody just want to have a nice day. So sometimes we don't get what we want, and then you have a choice to make. Right, the court is calling 2020-24 CR 011624 State versus Jan Hawkins, aka Jan Madura. Can I have parties announce?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Miss Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA is Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Oh, thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, well, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If your state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500, they're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected at toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out all, we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here.
Well, I am going to ask to a restitution hearing.
Okay.
And the fact these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So y'all will have to correct your paperwork.
Judge, if I may,
Mhm.
we've done this before. We are
Not with
pleading
me.
Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provided in the law for that purpose. Having us do, we've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the junior league.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why
least.
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings, and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this: if she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league, because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever, that's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know, to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence, and the judge can look at that and decide that they find those documents credible and find that they are true. And or
I can't do any of that if y'all are not stipulating to anything. Then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do
Oh,
not
y'all
stipulate to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the
They're
thing.
third
I haven't
parties.
read any of the evidence. So I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. this argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank you.
So yes, so everything needs to be reprinted and redone. Thank you.
Thank you.
All right, who's next? All right, and now you, Ms. Madura?
Yes.
Court will All right.
right.
find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. All right, with regards to the amount that's outside your agreement, we'll come back for a hearing. And at that time, I'll sentence.
Okay.
All right, Ms. Ferguson, I need a reset date. And this is just for restitution?
And Judge, are we going to have a full restitution hearing? If so, we're going to have to get a forensic accountant. I'm not an accountant, to go through all of the documents and bank records to prepare for that hearing. Your Honor, I would respectfully request if you would not order restitution or not make a decision and not have a hearing and let them handle that on the civil side in the civil courts.
Yeah, I'm not going to do that.
If I may respond briefly.
Yes.
Just the state's theory that amount be assessed as restitution is that is an amount the defendant received the benefit of. She can't keep.
I'm sorry.
She can't keep that benefit.
Okay. All right, we'll set it for a restitution hearing. Norma, I need a reset date for a restitution hearing.
And Judge,
You're out 45 days.
just to make it clear, we're not requesting that she keep anything. We are requesting that we get to the correct amount.
Okay. All right, we'll be back on December 11th. Once you sign the reset form, you're excused, and on that date, I will sentence. All right, thank you. You're welcome.
You need anything else from me, Judge?
No, that's all.
Y'all have a great day.
And we be excused, Your Honor?
Yes, once she signs the reset form. Well, the first thing is, we're supposed to figure out what the restitution is.
Judge, my client's decided she's not going to contest the amount.
And let me see. And when will she be able to pay this?
She'll have to pay it off during probation, Your Honor. She's already paid a substantial amount up front. So
I'm sorry,
about
how much?
1,077 and
Yeah, it was almost 11.
almost 1,100.
1,100.
So when do you anticipate paying this $1,077?
No, that was already paid.
that.
Your Honor, she's paid that already to our to the Junior League of San Antonio. The remaining is at the bottom of that where it says to keep Berkshire Hathaway in the amount of $9,799.42 and then $227.71 to Visa. So that's the remaining.
All right, so how much are you gonna pay monthly towards that?
Excuses, I need to.
Well, now, here's the thing. I'm going to order you to pay specific amounts monthly. So you need to tell me how much you're able to pay
We pay $500
per month. All right, is that what you think I want to hear? Is that what you can do?
That's what I can,
Okay,
barring any changes, no, that's what I can do.
okay, all right. Court is calling 2024 CR 011624 State versus Jan Madura. Can I have parties announce?
Andrea Crespo standing in for Chandler Bowen, Your Honor. Ready to proceed?
Linda Corley for defense.
And you're Miss Madura.
Yes, ma'am.
All right, based upon my calculations, you should be able to have this paid off before the 2 years. Do you understand? If you're paying 500 per month. All right, so we're here for sentencing today, and we were called back because there was a matter of restitution. Are both parties ready to proceed with the sentencing?
Yes, Your Honor.
Yes, Your Honor.
All right, this is what the court will do. Your agreement was for deferred adjudication, so the court will sentence you to 2 years deferred adjudication. The court will show that restitution of $77.01 was previously paid to the Junior League of San Antonio. Remaining restitution is $9,799.42 to Berkshire Hathaway and $227.71 to Visa. Restitution is to be paid in the amount of $500 per month. There's to be regular reporting by Zoom or in person, regular random UAs. Are you currently employed?
Yes.
And what do you do?
I am self-employed. I do contract work, accounting work over online.
Does anyone have any issues with her doing accounting work? And is this accounting work that you're doing, is there any exchanging of money?
No.
All right. Then proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be 80 hours of community service restitution, field visits 1 time per month for 5 months. Probation, is there anything else?
Yes, Judge. I think so. Which count?
Oh, I'm so sorry. They proceeded on the lesser included offense of theft, $750 to $2,500.
Okay, Judge.
And they're proceeding as a Class A misdemeanor.
Then, as far as the restitution is concerned, can you please give me those names?
All right,
I have Berkshire Hathaway.
yes, Berkshire, Hathaway, Hathaway. And then the $227.71 to Visa.
You said Visa.
Yes.
Nothing else, Judge.
All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So in this court, to be successful, probation communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back to the court.
Yes.
All right, and thank you for dressing appropriately for court, but you always do. I appreciate that. Thank you.
Thank you, Judge.
Anyone else ready?
Yes, ma'am.
Thank you, Your Honor.
Thank you.
Joshua Sutherland, page 2, 4 down.
Okay, just want to make sure you got me.
Joshua Sutherland.
Awesome.
Where's the attorney for Joshua? Sorry, your attorney's not here.
I apologize.
Who's next?
Yes, ma'am. John Gomez of 11.
Good afternoon. What's your issue?
I have a conflict of interest with Mr. Garcia. I wrote to the state bar last week because he hasn't, I guess we can't come to an agreement. He hasn't filed.
Now, here's the thing. This is what people always assume. People always think that they're qualified to be an attorney. You know why? And I discovered this from my time as a defense attorney and a prosecutor. They think that they can be attorney because they think all we do is talk. Now, you're about to say he didn't file some motion. Well, guess what? The state is obligated to turn over certain evidence for him. People always say, well, I want evidence that's favorable to me. The defense can file a motion asking for Brady material, but guess what? The state has to turn it over. And whether he files a motion or not, asking for them to turn over evidence that's favorable, they still have to do it. Right? Now, what I've discovered is sometimes people get made an offer. They don't like that offer. And they take that out on their attorney because the attorney is saying, hey, this is what the state is offering. But sometimes the person's like, well, I don't want that. I want something else. Your counsel cannot force the state to give you what they want. When the state makes an offer, you can think that offer is ridiculous. You can say it's ridiculous. Although I ask people not to do that because I want everybody to be kind to each other in this court. You can just say, you're not going to accept that. And then you know what? Your attorney will go to the state and say, the offer you made, he's not accepting it. Then you can say, well, I want to accept this offer, but this is what I will accept, which is called a counter offer. Then your attorney can go to the state and the state can think or say that's a ridiculous offer. But again, I encourage people not to do that because I want everybody to be kind. And they can say, I'm not going to make him that offer. Then guess what? You go to jury trial. The end. There is no being disrespectful to people. I always tell people, even if you don't like somebody, even if you don't appreciate what they're saying to you, there's no need to be disrespectful to each other. He has a job to do. He's trying to do his job. The state have their job to do. They're trying to do their job. I'm trying to do my job. The court reporter is doing her job, and everybody just want to have a nice day. So sometimes we don't get what we want, and then you have a choice to make. And your choice is either you're going to jury trial or you're not. Either you're accepting the state's offer or you're not. The state has tendered their offer, and that's their offer. And unless they decide to change it, that's the offer. And then when people have a counsel that is appointed to them, guess what? If you don't want your court appointed counsel, you can have anybody you want. You go out and hire them. I don't know why we've gotten to the point in this world where people want stuff for free and they want people to give them stuff for free. Oh, I don't like that one. You know, it's like if I go to the restaurant and they want to offer me free food and they say, you know what? You don't have any money. You're asking for free food. And I say, well, I don't want the rice that you're giving me. I want the steak and lobster. I don't want that sandwich. So this is your court appointed attorney. He's qualified to be your court appointed attorney. Now, if you would like to hire another attorney, you're more than welcome to do so. So are you going to hire an attorney?
That's what I would like to ask, Your Honor. I got, my bond was, I moved.
No, we're not talking about a bond. We're talking about whether or not you want to hire an attorney.
I'd like to be able to, if I can get out and purchase one or hire one.
And Your Honor, if I may, it has nothing to do with anything you have said. It has to do with personal. In the 27 years that I've been practicing, I've never been treated the way that Mr. Reyes has treated me. The names he's called me. I'm not going to help him. I'm not going to do anything further for him. It's ridiculous that he's treated me the way he's treated me, and I don't deserve to be treated the way he has treated me. So if you keep me on, I'm not going to lift one finger for him. I'm sorry. I've been doing this for 27 years. I'm old and I don't have to put up with
You're not old. Nobody's old.
Well, I'm older than I was 30 years ago. And so I don't need to put up with his shenanigans. And so he needs to either be appointed someone else that is going to put up with his, for lack of a better word, BS, or represent himself.
All right, you want to represent yourself? Or you want to hire an attorney?
Let's hire an attorney.
All right, we're going to go on the record. We're on the record in 2022.
Your Honor, I can't afford an attorney. I guess I'll just represent myself.
All right. We're on the record in 2022 CR 4920, State of Texas versus Raul Reyes. The court is in receipt of a motion to withdraw. State, do you have any objections to defense counsel's motion to withdraw?
No objections, Your
Honor. Mr. Reyes, do you have any objections to his withdrawing?
No.
All right. That will be granted. Thank you.
Thank you, Judge.
May I ask the question, Your Honor?
And Mr. Reyes, we're going to recall your case in 2 weeks. Ms. Ferguson, what's the 2-week reset date? All right, we're going to bring you back on April 10th. All right, thank you. We're off the record.
Is there a way I can get reconsideration on the bond that I've been paying for that was remanded? If I can get back to
No.
work?
You'll have to file a motion.
Okay.
All right, thank you.
Your documents, your your motion, some of the cases weren't making sense.
Oh, goodness. I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to.
I did, Your Honor, and that was something that I wanted to bring up today. So it's part of the reason why I didn't file a reply is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And so, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name. And
neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Sure. I'm pulling it up right now. Just bear with me 1 sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as the Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Just hold on 1 second. I'm trying to actually pull up the case itself. Hold on.
I'll be back I'm back.
there we go.
Okay. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193. It's an 8 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where.
As far as the citations go?
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Rowland versus Say case, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company. I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. In that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersion, I'm just facts. So he's been suspended in Maryland, and part of that was for lack of
Hold
candor.
on, where is he?
It appears that he either dropped off the Zoom call or lost internet connection, Judge.
I think he's coming back on. Hold on, let me see.
Okay.
Yeah. Mr. Gillespie?
I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr.
Please.
Gillespie, I'm a former staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess ChatGPT or whatever the legal version of the AI research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a 2nd-generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than happy to provide additional briefing copies of the cited cases, whatever.
I trust that Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if 2 lawyers are telling me that they've had additional briefing, is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Okay. Well, very good then. Should we? How would you propose we proceed?
Mr. Kennedy, this is also your client's case. Talk to me.
Yeah, Your Honor, I was mulling kind of what to do about it and what to ask for. And again, some of the stuff is going to relate to the summary judgment motion, which is not necessarily before you at this point in time. I would at least ask for my client's fees to be reimbursed for having to be here and respond to the motion or the response brief itself, which I don't have that number right in front of me, but I'm happy to supply an affidavit of what that is. Beyond that, I'm not sure if I don't want plaintiff herself to be penalized. So I just want to put that out there. I don't think she should be penalized because I don't necessarily think she has anything to do with this necessarily. It is more.
Well, the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court and the contumacious behavior is written in written form before the court. So I would definitely, always back myself up and look again at the statutes before I make a decision, especially on a contempt. But I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that.
Understood.
All right. All right. So what we're going to do is continue this hearing. We'll give you a date certain, and the court will consider that as well as any further action I have to take. But Mr. Gillespie, judges talk, and so if you practice in multiple jurisdictions, the word will spread. And so I just caution you to be mindful of that.
Thank you.
All right.
So, Your Honor, just to make sure I'm understanding, so we're just going to set another hearing where we'll take up the rest of this motion as well as probably summary judgment. And I know plaintiff filed a motion to withdraw deemed admissions, from RFAs.
I got it. I reviewed it.
Okay. And I know that's not right, but either. We just want to take all that up at one time down the road.
Yes, please. And I'll set you all separately.
Okay.
Ms. Powell, if you could just give me a date, maybe, some time out, and when we get the summary judgment motion, and then let's hear this case separate from any others.
Yes, ma'am.
All right. Thank you.
Number once again is 252423 GC. SAC Finance versus Regina Mast. Mr. Andrew Rognes is here on behalf of SAC Finance. A judgment entered in this case in Noble County, Indiana, and the amount of $7,718.26 plus cost and interest, and I don't remember what the actual amount was. Ms. Mast then became subject, I think, to a garnishment after Mr. Rognes registered this foreign judgment in Michigan, and the defendant filed a motion to set aside the default. But there are a couple problems. One, more than 21 days have passed since the entry of the default, and two, the default was in Indiana. And what is going on here is just a ministerial registering of this judgment from another state so they can try to collect it here. Ms. Mast, you filed a motion. I think we waived the fees. You attached a bunch of stuff about the car, and this is the same thing we always get, the car conked out. This happened 8 years ago, and the judgment entered in Indiana. And Mr. Rognus then registered it here. Mr. Rognus, you filed a brief, which I appreciate. You wish to speak to this further?
Yes, Your Honor. Originally, the promissory note or the contract was executed by Ms. Mast when she lived in Indiana. When they did file suit on this, they had to utilize what in Indiana they call an alias summons, and here in Michigan we call alternate service. And they perfected service in Indiana pursuant to trial rule 4.1. So I don't necessarily know that there is any basis to make a collateral attack on that judgment. And as I did indicate in our brief, I guess it's not ideal, but she's only accumulating interest at the Indiana statutory rate of 8%. Instead of the Michigan statutory rate at 13%. Certainly, if she wants to talk about setting up a wage assignment or something like that, our standard operating procedure is once they're paid off, we'll do a step to set aside the judgment, dismiss the case, help them out substantially with their credit history as well.
Ms. Mast, what triggered this? This judgment entered way back in 2017. And what normally happens is things just lay dormant until they actually start to try to collect. So what caused you to file this motion to set it aside?
I was never aware of it. They apparently served me the papers at an address I hadn't lived at for years. So I didn't even know about it until it was too late.
And they sent us a paper last year saying they're gonna put a lien on our property, and that's when we found out about it. Tell them that.
Yeah, we got a paper in the mail, I think last year, saying that they were going to try to take a lien out on property that I don't even own. And that was how we found out.
I have no idea, Your Honor. My presumption is that came from the Indiana attorney. But if you were aware at that point in time, you probably should have undertaken something rather than to waive that and be a stop from proceeding further.
Yeah, you have 21. First of all, Indiana says you were served by Deputy Sammy Bremer, B-R-E-M-E-R, on June 22nd, 2017. And he filed a document.
Okay, we didn't live there. We gave you a lease for a land contract house we purchased in 2017 before that date. And before that, we lived for a year in 2016 at 185. This is a motion to set aside because we were not properly served, whether it was 8 years ago.
He swore that he served you personally, handed it to you.
No, I don't think it says served personally, Your Honor. I think there's...
No. Oh, by their rule. Oh, yeah. Delivering copy of someone's dwelling house.
That's what this is about. We were never properly served. Therefore, it has to be set aside because we had no clue about it. We could never go to the trial.
Who's speaking?
I'm a witness to the matter that she lived with me.
You're not a lawyer. You're not a lawyer, and you can't represent Miss Mast. So if you just be quiet. Your ship sailed. You got served by Indiana service in 2017. Whatever that service was good enough for Indiana. So the judgment is Indiana. We then registered the judgment here. And all this business about the car conked out and all that stuff.
We're not properly served.
It's not necessarily a defense. This is a loan to purchase the car.
In 2017, I hadn't lived in Michigan for years, so I don't understand how that's okay for them to serve papers to a home I didn't live in.
That's the bottom line.
Well, it was good enough for Indiana to enter the judgment. So if you want to move to set the judgment aside, you have to do it in Indiana. I don't have the authority to set aside the Indiana judgment. Now let's assume they set it aside. In order to set aside a default judgment, generally, you have to establish a meritorious defense and a reason for not responding. Your reason for not responding is you contend that you were not served. I don't know what your meritorious defense is. We may set that aside and say, yeah, you do owe all this money. You borrowed this money, the car was repossessed, and this is what's left over after the sale. So,
I mean, worst case scenario, Your Honor, we
say that again.
Michigan on the promissory note, and then she's at a higher interest rate.
Well, that's not to her advantage, but it's an Indiana judgment. And I do not have the authority to set aside an Indiana judgment.
It's a Michigan claim, though. You're trying to take money out of Michigan. You're a Michigan lawyer. You're a Michigan judge, sir. We had no clue about this.
You're not a lawyer, so shut up. You don't have the right to speak on her behalf.
I'm a witness. I'm a character witness.
Witnesses don't just come in and represent the person that's the named party. So
the bottom line.
When you get a law degree, you can represent her and you can tell me what the law is, not something you read on the internet. This is an Indiana judgment that entered in 2017. Nothing was ever done. You never paid anything. You knew you had a judgment. At some point, you knew a year ago they had a judgment, and you never started to pay anything until they started to collect. So, Mr. Rognus, are you willing to speak with them regarding their options?
I will, Your Honor. If Ms. Mast would get in touch with me later on, or if you want to put her into a breakout room, if she's got the time, we've got another.
Let's do a breakout room. Sir, you can speak outside the court. So with Mr. Rognus, you can make your point, but
that's fine. We never knew about it. We're getting screwed. Now you're screwing us too. It's fine.
Okay.
We prove without a matter of a doubt that we did not live in Indiana. That's fair grounds for you to set this aside. We did not live in Indiana.
Stop. If you want to set it aside, you have to do it in Indiana.
This is a Michigan judgment, sir.
Yes, I understand.
Ms. Mast, if you want to get in touch with me, please do so at some point. It's obvious right now that maybe nothing's going to get it. Okay.
So do I have to go through Indiana court systems to do that? Is that it's been
well,
past
let's talk about this. Let's assume you set it aside. What's your defense? They set aside the judgment and then they just start over again.
It's your limitations.
What's your defense? You're supposed to file what's called a meritorious affidavit of defense that says, I don't owe this money because I was the wrong person. I already paid it off.
At the wrong place. They went and up through the back door, basically served it without actually serving me, just so that it would do that, and they would automatically get it because I did.
That service was adequate for Indiana.
How? I didn't live there. How is that adequate for anybody?
Those are the Indiana rules. You took out a loan with those people. That's the address you gave them. They sent it by first class mail. They posted it there. I can't speak to the Indiana rules, but Mr. Rognus cites it in his brief.
When they came and repossessed the car, I told them to come get it at my address where I lived in Michigan. They picked up the car in Michigan, so they knew I didn't live in Indiana. And yet they still served me in Indiana.
The judge thinks that you were served by a chief of police there when it never happened.
I'm not saying that you were served. Whatever service you got was adequate under Indiana law. And even if I did set it aside, they're going to say, you still owe the money because we had to repossess this car and sell it. And this is the shortfall.
The statute of limitations is 4 years in Indiana. So they're past their statute of limitations. If it's set aside, they can't bring it back up because it's past the statute of limitations.
Well, I don't know what the statute of limitations is in
Yeah,
Indiana,
4
but,
years. 4 years. It's been almost 10.
well, you can take it up with them.
Ridiculous.
Motion to set it, now, Miss Mass, let me repeat. You got a couple options. You can call Mr. Rognus at any time and he'll speak. You can go to Noble County and try to set the original judgment aside. This is a Indiana judgment that was registered in Michigan. It complied with the Indiana rules and we registered it here. So I'm not saying that it's fair. Thought I had an order in here. I do. Anyway, the order to set aside the default is denied. First of all, once you get notice of it in Michigan, you have 21 days to move to set the default aside, which you didn't do.
You were on vacation, sir. We did that. We did that.
All right, you shut up. You just shut up. You don't have the authority to speak.
Stop lying, Judge Middleton.
The motion to set aside the default was filed
on December 18th.
Soon as we got it in the mail. Soon as we got it in the mail, we filed a motion. You were on vacation, sir.
All right, let's take a look.
Yeah.
Again, shut up. You don't have the right to say anything. You just
don't call me shut up, sir.
I'm gonna mute her microphone. Yes, he doesn't have the authority to represent her. He's a witness. Somehow this got lost by the clerk. They did file it on December 18th, and I didn't see it until January 21st. And they set a hearing date and they entered a garnishment before we had the hearing on the motion to set aside the default. And then I think maybe it was set the day the courthouse flooded. So we moved the hearing up and we reset it at an unusual time, which was this morning. So the time that you filed the motion to set aside the default was not from the time that you learned you had a judgment. It was for the time they started to garnish your wages. Those are two different things. So the motion to set aside the default judgment is denied. It's an Indiana judgment, and the judgment was entered in Noble County, Indiana, which apparently complied with the Indiana rules. I don't believe I have the authority to set aside an Indiana judgment, whether you were properly served or not. If you were properly served, then the judgment stands. They filed something called, and Mr. Rognus provided you a copy of it, an alias summons, which is an Indiana statute that allows them to do what we call alternative service. And secondly, once you found out about the Michigan judgment, he didn't file the motion within 21 days to set it aside. He filed it within 21 days of being informed of the garnishment. So the motion to set aside the default is denied. You can talk to Mr. Rognus at any time. You can call his office, or you can contact the officials in Noble County. But you don't want this garnishment. It's going to take a great big chunk of your money. They can agree to something like an installment payment order or something else. I do have the authority to change the payment. If you filed a motion for installment payments, I could set aside the garnishment on that basis, but I can't set it aside because it's from Indiana. Let me repeat. You can contact Mr. Rognus by phone at any time or stop in at his office. He will discuss this with you. He has the authority to set aside this garnishment and enter into some sort of repayment agreement. you can ask me to set aside the garnishment with a request for installment payments. Or you can go to Noble County, Indiana, and try to set aside the original judgment from 2017. That is not going to be easy to do. This alien summons that they have in Indiana was apparently sufficient for the Noble County Court to enter a default. All right. I guess you don't have to like it. I probably wouldn't like it either. The other issue is whether you have a meritorious defense, even if it is set aside. Your argument that you don't owe the money is going to have to be prevailed in Indiana. So, all right. I'm sorry you don't like it, and I wouldn't like it either, but your motion set aside the default is denied, and I will do the order. All right. And again, you can contact Mr. Rognus at any time. It isn't respectful to tell people to shut up, so I kind of lost it, but
I've dealt with him before. I don't know.
I didn't even get his name.
Yeah. He was the dog charge case from Constantine when I was still working with Dave in the prosecutor's office.
Anyway, she's in a tough spot, but the fundamental thing, they probably don't have a meritorious defense.
Yeah.
So even if it is set aside in the other state, she's going to have a hard time. So she's just going to have to look at a way to pay this.
And I'll talk with her about setting something up.
All right.
Just thought maybe call me on a different date when he's not all.
Well, you were willing to go into a breakout room, but you could see that it wasn't going to go